everyone, from wherever you are listening, we welcome you to the podcast Accountability Youth Takeover Series, where we, the Youths in Strengthening Democracy Fellows, will bring over the voice of the youth in pressing issues that matter in today's youth and explore the intersections of democracy, human rights, and accountability. It's me, Bobita Tamang.
And it's Arya Gimire.
And we will be talking about, in today's episode, about clemency, the pardon culture in Nepal, and also some scenarios all over the world. Okay, so Arya ji, on today's episode, we definitely are going to be talking about the culture of pardoning in Nepal and also all over the world, various cases and the situations zanira चाहिँ pardon दिएको छ. But before we just dive into the word pardon, let's talk about what is clemency. What do you think clemency is, Ani? What is your idea of clemency?
In a broad concept, clemency means giving leniency towards any sort of judgment or execution, may it be criminal or civil. But it's been used as a means of giving some sort of leniency, for example, pardoning the offense or reducing the sentencing in case of criminal justice system by the executive in the current situation.
So when we speak of an executive's or official's power to grant clemency, be it a president or a governor or any head of the state who has the power to give clemency, are we talking about only the situation where they show leniency or mercy, or does it go beyond that? I feel like clemency is more than that. It's about giving someone forgetting about their crime, forgetting about what they have done politically, criminally, or civilly. It's also believed to be an act of grace that is based on fairness, that is based on justice and forgiveness, right? Do you have anything more to add on the culture or just the clemency itself?
If we look at clemency just in the broad context of what clemency is perceived in democratic country, I do agree what you are talking about. It's an act of grace, but also it's an act of, I think, making amends for the mistakes done by the judiciary. Because we can say that judiciary is not a perfect institution. And if it comes to criminal law and morals that's associated with law, it's not completely perfect in nature. There are a lot of things, a lot of loopholes, and a lot of situations where individuals who are on the bottom of the barrel when it comes to societal hierarchy, when it comes to systemic oppression, are wrongfully convicted, or they've been forced to commit a crime for survival, right? So I think clemency, in a broad sense, if you look at the objective nature of clemency, was something that was established to kind of mitigate the flaws of judiciary. Yeah.
So, यसरी flaws के बारेमा कुरा गर्ने हो भने, like, do we agree that when a clemency is being given or any pardon is being granted, that the judiciary takes the acknowledgement that it has committed any wrong भनेर? I think to some extent it does, that the judiciary has committed some kind of flaw, some kind of wrong, and that the executive is there to correct it, right? Ani, in a very broad sense, clemency bhanne is like, literally it talks about fairness, it talks about being kind, being merciful. Talking about clemency further, why do you think clemency was introduced, or why do you think it serves as part of any justice system?
As I've already mentioned, Ogadi, that I think it was something that was introduced to address the loopholes and I think the weaknesses of justice system itself. Because again, as any other human-made system, justice system is not perfect, and there are a lot of things that the justice system does not take in account for, right? And also in a lot of countries, and including Nepal, there is no idea, fully executed idea of transformative justice, where they focus on criminals, quote unquote, that they have actually imprisoned to kind of like transform themselves, to be engaged in activities within the prison system that would allow them to come back to the society, or that would allow them to acknowledge the crimes that they committed, or acknowledge what they were imprisoned for, right? So I think यस्तो खालको कुराहरूलाई address गर्नलाई clemency को establish गरिएको हो हुन्छ नि, as a and in Nepali context, not in just Nepali context, South Asian context, हामीले clemency को idea, we see it in like हाम्रो Vedas देखि लिएर राजाहरूले गरेको systems-हरुमा, they would give pardon to individuals back then, right? अनि if we look at a lot of past ko laws-हरु पनि, it was unfair, right? पहिला what was considered to be fair, like if you think about it, intercaste marriage ma कतिवटा क्राइम लाइक पनिसमेन्टहरू दिन्थ्यो, राइट? वुमेन भएर सर्टेन काम गरेकोमा कतिवटा पनिसमेन्ट दिन्थ्यो. तिमी आफ्नो कास्ट सिस्टमको हायरार्कीमा नबसेर बाहिर गएकोमा कतिवटा पनिसमेन्टहरू दिन्थ्यो. सो आई थिङ्क त्यस्तो खालको कुराहरूलाई मोर अर लेस एड्रेस गरेको जस्तो लाग्छ when it comes to clemency. But on the other hand, again, power given to whom? People who are on the hierarchy of the social system in itself, होइन? तिनीहरूको मर्सीमै बाँच्नु परेको थियो clemency.
So, the modern democracy ma herne ho pani, the entire concept of check and balance, can we say that clemency is an additional tool to check the unjust outcomes or unjust, products by the criminal justice system itself? I am focusing very much on criminal justice system, kinabhane the entire social liabilities haru dekhi liera yo power distribution ani hamro society ko hierarchies and norms haru pani elai tangible banaunako लागि नै यो सबै acts हरुलाई चाहिँ criminalize गरेको छ. So I'm so sorry, I'm just using the word criminal time and again. We should also, I think, emphasize that clemency is more like an empowerment rather than, right itself. Or let's say it's more of a privilege that is given to chief executives, especially president, हाम्रो नेपालको कन्टेक्स्टमा, and in a lot of other countries as well, or prime ministers or the council of ministers, उनीहरूलाई चाहिँ it's a privilege that is given to them to correct injustices based on case-by-case basis that might have been committed by a judiciary. So in a way, yahanira executive र judiciary को चाहिँ close connection देखियो. Do you agree on that?
I completely agree on that, because let's just look at clemency like कसरी establish गरेको छ नेपालको legal system मा नै, हैन? त्यसले नै यसलाई clarify गर्छ, right? So let's look at हाम्रो legal system मा चाहिँ the first mention गरिएको one of the like हाम्रो hierarchy मा सबैभन्दा माथि भएको legal document is constitution, right? So हाम्रो constitution ले directly के भन्छ भन्दाखेरि I think article 276 ले president लाई चाहिँ pardon को right दिएको छ, right? So pardon को right दिएको छमा it was mentioned everything that you're talking about, not just clemency like pardon मात्रै, it's talked about commute को कुरा, reducing sentencing को कुरा, a lot of things that quasi judicial body र judicial body ले गरिएको छ, administrative authority ले गरिएको छ. If you look at the nature in itself, executive is actually in kind of like executive is intervening at the decision taken by judicial or quasi-judicial bodies. So obviously you can look at like see that there is some sort of like हाम्रो just like separation of power जुन चाहिँ concept छ rule of law मा, त्यसमा दिएको privilege भनेर देखिन्छ. And why is it considered a privilege भन्ने कुरामा पनि, because हाम्रो constitution ले भनेको कुरालाई limit गरेको अरु laws-हरु छ. So pardoning, the whole idea of like pardoning जुन चाहिँ अहिले भइरहेको छ, त्यसलाई के मा चाहिँ हामीले pardon गर्न मिल्छ र के मा गर्न मिल्दैन भनेर फेरि legal tool ले नै एउटा limitation दिएको छ नि त. So the limitation itself will show that this is not a power, this is a privilege given to our executive भनेर.
Right. यो constitution मा छँदैछ अनि constitution को additional व्याख्या भनौँ न, additional interpretation गर्न help गर्नको लागि चाहिँ there are other laws as well, जस्तै हाम्रो criminal procedure code of 2074, त्यसमा पनि धेरै कुराहरू लेखेको छ हैन. Mostly it's the most defining law, किनकि यो general law पनि भयो. तर फेरि when we move further towards यो prison regulations or the Prison Regulation Act or other यो criminal offenses sentencing policies हरु, do you see loopholes there? Do you see loopholes where where, executive can overtake the power of the judiciary?
So I think Nepalko context there are two questions that come forward when we talk about clemency, right? First चाहिँ यो नेगेटिभ लिस्टहरु छ नि जुन कुराले चाहिँ लिमिटेसन प्रोभाइड गरेको छ त्यो नै एउटा स्ट्रक्चर्ड लमा छैन. इट्स स्क्याटर्ड एभ्रीवेयर इन डिफरेन्ट like हाम्रो legal documents haru. First of all, as you mentioned, it's National Criminal Procedure Code. त्यसपछि हाम्रो I think the other one is Criminal Offences Sentencing and Execution Act. This is Prison Regulation Act, right? So तीनटा like major document मा चाहिँ mention गरिएको छ when you can pardon, when you cannot pardon. तर के देखिएको छ भन्दाखेरि चाहिँ National Criminal Procedure Code ले एउटा नेगेटिभ लिस्ट बनाएको छ. नेगेटिभ लिस्ट एज इन यो कन्टेक्स्टमा चाहिँ पार्डन दिन मिल्दैन भनेर लिस्ट बनाएको छ. अनि यसमा चाहिँ अलिकति हिनियस कुराहरू लाइक अलिकति मोरली नै इनकरेक्ट हुने क्राइम्सहरूलाई मेन्सन गरेको छ. जस्तै करप्सन भयो, रेप भयो, जेनोसाइड भयो, ट्राफिकिङ, ह्युमन ट्राफिकिङ भयो, अनि मर्डर इन अ क्रुल एन्ड इनह्युमन वे भनेर भनेको छ. ड्रग ट्राफिकिङको कुरा गरेको छ होइन. अनि एनिथिङ द्याट इज सेन्टेन्स फर लाइफ इम्प्रिजनमेन्ट जो चाहिँ 3 वर्षभन्दा बढी एक्सिड गर्छ त्यस्तो खालको टर्म्समा चाहिँ पार्डनिङ दिन मिल्छ भनेर भनेको छ. वेयर एज वेन वी गो टु हाम्रो वी टक अबाउट प्रिजन रेगुलेसन एक्टमा प्रिजन रेगुलेसन एक्टले त फेरि छुट्टै एउटा कसरी पार्डन ग्रान्ट गर्ने भनेर लिस्ट बनाएको छ, राइट? अनि यो लिस्टमा चाहिँ देयर आर सर्टेन थिङ्स द्याट इट हेज एडेड, राइट? इट हेज एडेड क्राइम्स सच एज प्रिजन ब्रेक, एस्पियोनाज, क्राइम्स रिलेटेड टु हेरिटेज, स्मगलिङहरू एड गरिएको छ. सो यो दुईवटा नै नेगेटिभ लिस्ट एक्जिस्ट गर्दाखेरि चाहिँ कुनलाई फलो गरेर गर्ने त भन्ने क्वेसनमा चाहिँ देयर इज अ लट अफ लाइक एम्बिग्युटी that exists.
अनि त्यो लिस्टमा एड गर्दाखेरि चाहिँ I've also found यो क्रिमिनल अफेन्स सेन्टेन्सिङ एन्ड एक्जिक्युसन एक्टमा चाहिँ यो करेन्सी काउन्टरफिटिङको पनि I don't think that's one crime that is really popular, किनभने अभियसली क्राइम्स भनेपछि त लुकेर गर्ने अर्गनाइज्ड वेमा गर्ने हुन्छ नै, बट देन क्राइम्स लाइक मर्डर, करप्सन यिनीहरू चाहिँ वी टक मोर अबाउट देम अनि इट्स पपुलर एन्ड देन धेरैजनाले बुझ्ने क्राइम नै भइहाल्यो होइन. अनि आई थिङ्क मोर अर लेस दिज क्राइमको यो क्राइमको लिस्टहरू चाहिँ रिपिटेड त छँदैछ, बट देन वेन वान एक्ट मेन्सन्स वान क्राइम एन्ड द अदर वान डज नट, अभियसली त्यहाँनिर एम्बिग्युटीको कुरा त भइ नै हाल्यो, लाइक विच वान टु प्रिभेल ओभर द अदर वान भनेर है. When we follow, like, do you think यो नेपालमा चाहिँ if we look at the constitutional history 2047 को constitution देखि नै यो presidential pardon को provisions चाहिँ दिएको थियो होइन. So pastदेखि अहिलेसम्म चाहिँ what do you think the narrative has been like in the scene of clemency?
Okay, so I think there are two things that I'd like to talk about when we think about narrative shifting, and I think the thing stems out of Oileko context, Nepalko context. The question stems out of legal provisions, first of all. So legal provisions, when there are certain things that I would like to talk again, right? So you said clemency ko power diyeko cha president lai Nepalma. Now, if you look at other countries, for example, in India, अनि in US, head of the state like clemency को power दिएको छ, तर clearly यो decision चाहिँ head of the state को हो भनेर mention गरेको छ, right? So नेपालको कन्टेक्स्टमा चाहिँ के छ त? So नेपालको कन्टेक्स्टमा यस्तो छ है, हाम्रो कन्स्टिट्युसनले के भन्छ, प्रेसिडेन्टसँग पावर छ to give clemency, the range of like broad range of different types of clemency दिने पावर छ भनेर भनेको छ. तर फेरि सेक्सन 159 मा गयो मुलुकी क्रिमिनल कोडमा चाहिँ प्रेसिडेन्टले cabinet of minister decision on the request of pardons such as petitions are made to the president, not to the executive भनेर भनेको छ, right? So president सँग चाहिँ decisions-हरु गर्ने authority छ, तर for only those petitions that are made to the president. So कुनै imprisoned prisoner ले चाहिँ petition forward गर्छ presidentलाई भने प्रेसिडेन्टले चाहिँ क्लेमेन्सी दिने, त्यसमा दिन पाउने अधिकार छ भनेर भनेको छ हैन. सो अब यसलाई कसरी आउटलाइन गरेको छ, पिटिसन इज मेड बाई द कन्भिक्ट टु द प्रेसिडेन्ट, तर थ्रु द होम मिनिस्ट्री with a copy of court's decision.
So भनेपछि obviously जोसँग चाहिँ access छ, only those prisoners will have the chance to even write a petition, right?
So that depends, right? Because I think a lot of people are like, we can send a petition like pardoning ko petition through your lawyers or like timro ke anybody, your legal representative or individually pani. There are people who have sent petition after letter lekhera through prison system itself. There are questions ke bhayo bhandakheri through the cabinet of minister bhanera bhaneko cha ni ta. So is it solely the decision of president? भन्ने क्वेसन पनि छ. बिकज अब नेपालको कन्टेक्स्टमा हेरौँ, वी आर टकिङ अबाउट सो रिसेन्ट केस छ योगराज ढकाल, रिगलको केस आएको छ है. रिगलको केसमा र आई थिङ्क देयर आर अदर केसेस वेयर द लिगल एडभाइजर अफ द गभर्मेन्ट क्लियरली के भनेको छ भन्दाखेरि क्याबिनेट अफ मिनिस्टरले लिएर आएको डिसिजन अफ पिटिसनलाई प्रेसिडेन्टले नाइ भन्न त ठाउँै हुँदैन. प्रेसिडेन्ट ह्याज टु गिभ देम क्लेमेन्सी भन्ने कुराहरू आएको छ के. सो एन्ड देन टाइम एन्ड अगेन लिगल एडभाइजर्सहरू र आई थिङ्क गभर्मेन्टको साइडको लाइक लिगल रिप्रेजेन्टेटिभ्सहरू have been kind of like advocating for that. They've been kind of like defending that cabinet of minister लिएर आएको clemency को जुन चाहिँ petition छ त्यो president ले नाइ भन्न पाउँदैन भनेर भनेको छ. Now the question arises यसमै, like कसको त right हो त त्यसो भए? If president ले no भन्न पाउँदैन भने is it president's decision or is it cabinet of minister को decision? Also यो cabinet of minister को throughबाट गयो भने I mean executive सम्म जानु भनेकै political interference हुन्छ भन्ने 100% sure हो. तर now you're going through cabinet of ministers where there are different political parties with their own agenda, with their own like एकअर्कालाई different political partiesहरूको तिनीहरूलाई आफआफ्नो लागि vote चाहिएको छ within the cabinet of minister itself. So यस्तो खालको cabinet of minister बाट आएको decisions-हरू चाहिँ do you think it would not be politically affiliated? And has it not been reflected on the cases of pardon that you've seen in this past 10 years in Nepal?
Yeah.
That's the question, right? So, Nepal's context, I think we can kind of like get into the context of pardoning from your lens, just I'd say.
Yeah, so narrative na हेर्ने हो भन्दा पनि हुन्छ नि, from the time when the king had, you know, no interference on whom to grant the pardon to like the president's power, which is so much intervened by the cabinets of ministers, political parties. And again, यो 2072 को constitutionally grant गर्ने अनुसार the right of the victims of the crime मा चाहिँ यो केसेसहरु विथड्र गर्न मिल्दैन because it is unfair to the victims भन्दै गर्दाखेरि आउने अरु interferencesहरु that should be based on public welfare भनौं न. So you know, यहाँनिर when we see the narrative shift, it's always about the political interference, right? Exactly.
Ani public welfare bhandaheri again, if I mention this or not, that brings to hamro Supreme Court ko euta precedent, right? So Bharati Sherpa versus the office of president bhanne case ma hamro Supreme Court le ke bhaneko थियो भन्दाखेरि चाहिँ any sort of pardoning, that is remission, respite, reprieve or commutation, I think I mentioned agadi नै, should be based on public interest भनेको छ. So public interest and prevailing laws and the rulings of the Supreme Court भनेर अगाडि भनिसकेको छ. Now यसमा there is a अलिकति tricky position के हुन्छ भन्दा हाम्रो Supreme Court को precedents-हरु नै are not as strong as अरु country को Supreme Court को precedents-हरु, because अरु country मा एउटा precedent set भएपछि it's very difficult to overturn that precedent, right? त नेपालमा चाहिँ के हुन्छ 5 वर्ष अगाडि particular same type को केसमा एउटा precedent दिएको हुन्छ भने 5 वर्षपछि फेरि easily अर्को precedent set भइसकेको हुन्छ. There's a lot of contradicting precedents-हरु हैन. तर if there is a precedent that's already set, then the precedently clearly के भनेको छ, public interest, legal prevailing laws and ruling of the Supreme Court भनेर भनेको छ, right? So त्यसलाई has been carried on in another decision जुन चाहिँ हाम्रो रेशमलाल चौधरीको केसमा थियो. When रेशमलाल चौधरी was given clemency, त्यतिखेर के भनेको थियो भन्दा सुप्रिम कोर्टले पोलिटिकल एडजस्टमेन्ट, पोलिटिकल बार्गेनिङ को लागि क्लेमेन्सी दिइन्छ भने त्यो भनेको भायोलेसन अफ कन्स्टिट्युसन and established legal norms हो भनेर भनेको छ. So clearly के भनेको छ, political affiliation bargaining को लागि you're giving it, it's a violation of norms. So दुईटा भयो, political is violation of norms. Second, legal provisions हरुबाट it should not sway away. So legal provisions को within नै गर्नुपर्छ भन्ने context आएको छ, right? तर फेरि अर्कोमा के भनेको छ, बलराम यादव versus Council of Minister को केसमा के भन्नु छ भने चाहिँ, if within the law, within the legal like provisions clemency दिएको छ भने सुप्रिम कोर्टले इन्टरभिन गर्न पाउँदैन भनेर पनि भनेको छ. And this brings out a really interesting question रिगलको केसमा. बिकज रिगलको केसमा चाहिँ के भएको छ भन्दा क्लेमेन्सीको कन्टेक्स्टमा चाहिँ पहिलाको ल जति जुन बेला रिगललाई चाहिँ लाइक जे होस् कोर्टमा लिएर आइयो अनि उनलाई लाइक क्रिमिनल चार्जेसहरू लगाइयो, त्यतिखेरको लको बेसिसमा चाहिँ लाइक क्लेमेन्सी दिएको हो, नट अहिलेको लको बेसिसमा भनेर हाम्रो गभर्मेन्टले चाहिँ एउटा स्ट्यान्ड दिएको छ क्या. सो यो केसलाई क्वेसन गर्यो, स्टे अर्डर आयो, सुप्रिम कोर्टले स्टे अर्डर दियो, त्यतिखेर चाहिँ हाम्रो गभर्मेन्टको वान अफ द स्ट्यान्ड चाहिँ त्यो हो. सो त्यसमा 40% क्राइम गरेको, 40% चाहिँ लाइक सेन्टेन्सिङ कम्प्लिट गरेको हुनुपर्छ भन्ने कुराहरू आएको छ क्या. सो अब लिग्यालिटीमा इट्स ओके भनेर गयो भने इज इट गोइङ टु, लेट्स से रिगलको केसमा लिगली फाइन रिगललाई क्लेमेन्सी दिन पाइन्छ भनेर भन्यो भने डु यु थिङ्क इट्स गोइङ टु legally illegal नभए पनि do you think it's going to carry out the spirit of actually what clemency is meant to be for?
Exactly. The clemency is actually meant to be for fairness and for justice, and also for your victim or relief ko lagi. But is the victim of the case of Regal really relieved by the pardon money? Any question now, okay, right? So that really brings us to the question: how is clemency an issue of accountability money? Right? It's if we go back to our own statements that clemency is actually a privilege of the executives and not the right that is inherent on any executive power. So if we see the way clemency is used, it's used more like a right. Okay, and it claim नै त्यसरी गरिरहेछ. You just mentioned कि यहाँको legal officers हरूले नै that the president does not really have a ground to question whether or not यो क्याबिनेटले grant गरेको pardon चाहिँ दिन मिल्छ कि मिल्दैन भनेर. So it's more like hog जमाको जस्तो भयो के, but which is not really true, right? Which does not carry the spirit of the clemency. It should be used as a privilege to correct the judiciary's decision. And judiciary, merely if we see based on the principle of separation of power, judiciary has the final say on whom to declare a criminal, whom not to declare a criminal, right? So what do you think? How is clemency an actual issue of accountability?
नेपालको कन्टेक्स्टमा in past few years कस्तो केसमा चाहिँ clemency use गरिएको छ. अनि all of these cases have been quite controversial. अर्को कुरा हेर न, all of these people who have been pardoned, तिनीहरूको social capital exist गर्छ के. That means once they're out, the victim's family, they should feel threatened.
Exactly.
They will feel threatened. It's not going to change like how it's not going to change their behavior. What does that mean? Does that mean that the person was prison ma basera ule afno crime na reflect gareko ho ki the person showing that I can do anything that I can because there is impunity, because political affiliations are, because these political parties who are supposed to be accountable for the safety, also accountable for the democratic structure, use people like us to do their dirty deeds. That's why we have more power and we can do anything that we want in this country.
Exactly, and that is a very, very big issue of good governance, big issue of rule of law, and especially a big issue of accountability. And that's why I think this podcast was very important for us to talk openly about, clemency being used as a political tool, clemency being used as a tool to, hide the dirty deeds of political parties in present. So यो कुराहरुलाई हेर्ने हो भने the actual objective of clemency is not being being met, right? And all these acts are just taking the core value of clemency further and further away, and it's only being used as a particular tool to achieve something. So that's why I think this podcast was really, really important, and this was also very fruitful. Thank you so much for being part of this Accountability podcast. It was really amazing talking to you. It was really amazing sharing my own opinions, and thank you very much. Keep in touch with us and stay tuned for upcoming series. Thank you.
Have a great day. Bye-bye.